Hello, my name is John Milburn. Today I'd like to speak about Chapter 4 of Environmental Law in Australia by Jerry Bates. It deals with international environmental law. And in this chapter, Bates explores the role that states have in regulating their international affairs. We discuss the source of international environmental law. We talk about the source of international environmental law, and that's conventions and treaties, customs, general principles of environmental law, and judicial decisions and the teaching of publicists and academics. The issue of compliance and enforcement of international matters and agreements at an international level is discussed, together with matters of environmental rights and human rights. Finally, we discuss the role that international law has in the Australian domestic law. Now, the main difference between domestic law and international law is that the participants in international law, except for human rights cases, are countries. And we refer to countries in that context as states, as opposed to states of Australia. We talk about states at an international level, which are countries. So we'll talk in international law about states rather than individuals or corporations law. So international law in an environmental context is very much about the relationship between nations. This form of international law is referred as public international law. That's as opposed to the body of law which is known as private international law, and that governs the international relationships of individuals and corporations with one another. And in our global economy, that branch of the law known as private international law is becoming more and more important. So the first difficulty we have in talking about public international law, that is the law that regulates the behaviour of states, that is nations, with one another, is to try and identify what exactly is the law. It's hard enough at a domestic level, as we've discussed in previous talks. So in dealing with what is the law at an international level, we need to consider what are the sources of the law, how is it regulated, and how are disputes decided. So once again, we come back to that separation of powers issue. So in municipal or domestic law, it's quite easy to determine. There are clear and enforceable powers and rights conferred through primarily legislation, but also case law. But when we're dealing with countries at an international level, it's much more difficult to define. One difference is that in a domestic context, once the law is settled, citizens have effectively no choice. They must comply with the law which is stated. But when it comes to an international perspective, there is a difficulty, a very fundamental difficulty of who makes and who enforces international laws. Essentially, the government is answerable to the international community for its conduct. But international law has no direct effect in this country, in Australia, until it is enacted into domestic law by Australian parliaments. So, for example, a breach of an international obligation is not, merely for that reason alone, enforceable in Australian courts. All right, so let's talk about the sources of law. Firstly, I guess treaties come to mind as probably the most obvious example of laws that are created at an international level. But international law is not just what is contained in treaties. It also refers to what has been determined through general principle and the customary behaviour of nations. So at an international level, let's just say that there are two main sources of law. There's the hard law and the soft law, to use the terminology used by Bates. So what do we mean by hard law? Well, probably the most obvious example is an international treaty or a convention. There are, however, to contrast that, principles of international law which have become accepted by the international community as being law, through customary acceptance, and these are those things which are accepted by international community as being binding, if you like, upon a state, but have not yet formed the status of hard law documentation. So a good example, and one that we often talk about during discussions on environmental law, is this concept of the precautionary principle. It's not yet part of the hard law in terms of international law. It's still part of the soft law category, but it is one which is now readily accepted and acknowledged by states at an international level. In talking about hard law, we should consider the Statute of the International Court of Justice, and Article 38 provides that in deciding disputes between states, the international courts may rely upon international conventions or treaties, international custom, general principles of law, and the judicial teachings of academics. So they're the 5 sources of international law that I talked about at the start. So the reference for that as being appropriately considered by international courts is Article 38 of the Statute of International Court of Justice. Now these rules, if you like, only bind states. They don't bind individuals. But as we discussed, international law may be passed where the international treaties and obligations and customs are incorporated into domestic law, and that would then become binding upon individuals in a domestic setting, not because of the international law, but because of the domestic law which was created to reflect the international law. All right, so let's talk about these different sources. Number 1, the first source of international law is international convention or treaties. International conventions or treaties are the most common and straightforward of the various sources of international law, partly because it's written and it's clearly identifiable. These conventions or treaties are essentially agreements between nation states which regulate particular activities. Now, those activities don't have to be binding upon all states, that is all nations. The treaties or the conventions may simply be between 2 states, in which case they're called bilateral agreements, or they may be between a number of states, in which case they would be called multilateral agreements. Now these treaties or conventions, they tend to be reactive rather than proactive. In other words, they'll come in after the event, but there are some precautionary measures which do come into some of these treaties, such as the Kyoto Protocol. Now, once the agreement at an international level is reached, the particular convention under consideration is opened for signature and ratification of nations or states. And the nations become bound by a particular convention, not by signature, but by rather the act of ratification. So they're open for signature and ratification. Once the signature is inserted, that doesn't bind the nation, but rather the next step, that is the act of ratification, is what will bind the state. Now, in Australia, it is the federal government of the day rather than Parliament which makes the decision to ratify a particular treaty. So that's done at an executive rather than judicial level. A parliamentary level. So at an executive level rather than a parliamentary level. Bear in mind, of course, that environmental treaties are intended to be quite broad in their scope, and they create essentially a framework. So these treaties tend to be regarded as framework treaties. It provides the general principles to which the parties agree to be bound, but it leaves open for further discussions and negotiations the precise details which have yet to be agreed. In a sense, you can use the analogy of international treaties and conventions as something similar to the primary piece of legislation, which is then subject to delegated legislation to fill in the gaps at a later time. All right, so that's the first source of law, international treaties and conventions. The second source is international custom. International custom is also known as customary law, and it is essentially, if you like, the unwritten protocols which are generally accepted practice on a particular matter. One important principle is that of good neighbours. So the principle of being good neighbours in an international context means that there are clear ways that nations are expected to act when dealing with certain issues which may have an effect on their neighbours. So the general rule is that when taking decisions at an international level, the nation or the state must take into account the rights and interests of its neighbours, and that's what we would call customary rule. Now, the treaties are often eventually signed which define and develop those customary rules. So in other words, the second type of international law, which is this concept of international custom, may be upgraded to a treaty, but if it's not, it's treated in this unwritten but still generally binding fashion. There is, if you like, a legal sense of obligation that nations have in the way that they should behave, and that is reflected by this state practice. So that is, if you like, the second source of international law, that is international custom. Let's go on to the third source, and that is the general principles of international law. These are, if you like, general principles of international laws which are recognised by civilised nations. In that sense, customary law and general principles are very similar in the way they are in effect. And the fourth and final, if you like, or fourth and fifth, are the teachings of publicists and also the decisions of judicial decisions. So they form part of the overall body of law. So the decisions of international courts essentially become akin to our common law. All right, so that's the sources of international law. Let's talk briefly about compliance and enforcement. Enforcing legal obligations in an international law complex is, of course, much more complex than in domestic law. There is no particular world regulator to take countries to court and prosecute them. It is growing, but it's still very much a work in progress. Now, acceptance of treaty obligations and consequent compliance with those obligations tend to be easier where the nation states have no economic interest in the subject matter of the treaty. It's pretty easy. We've got nothing financially to lose, so we can take, if you like, the higher ground. It's a bit more difficult for nations or states to deal with those issues or comply where they have a direct and dramatic, if you like, economic consequence to them as a result of doing so. Now, in 1991, a United Nations Compensation Commission was established, and that was required to determine claims in respect of Iraq's unlawful invasion of Kuwait, and there were claims purely for economic damage, or there were successful claims and substantial claims for economic damage were awarded in those circumstances. Where there are breaches of international law, rather than necessarily trying to litigate first up, there are a number of ways in which compliance might be sought. The first, probably fairly obvious, is to try to negotiate. And that would be much the same for individuals that are involved in a dispute situation. So the same applies for states. Someone has breached an obligation, the first thing to do, try to negotiate a resolution. But if that fails, you can move on to a more formal arrangement, much the same as individuals, and that might entail, for example, mediation. Now, in the same way that mediators in a domestic situation have no power to make orders or make any order to resolve the matter, mediators in an international context likewise have no power to make orders which will bind the parties. So, in the same way in domestic situation disputes, if mediation isn't successful or is regarded as being unlikely to be successful, perhaps the parties can go up a notch and go to conciliation. So conciliation is a bit like a halfway house, and that is where the conciliator has more power than a mediator. The conciliator can suggest solutions, which the mediator in a pure sense cannot do. And in a conciliation situation, the conciliator has power to make certain directions, but cannot make binding decisions upon the parties. The next step up from that is binding arbitration. And it's a form of settlement where the parties agree to be bound by the decision of the arbitrator. So it has some of the hallmarks of mediation and conciliation, but it's one step above, and that is where the arbitrator says, I've heard from both parties, you haven't been able to resolve it, so this is the decision that I make. Now, beyond that, the only other recourse is to go to the International Court of Justice. Bates makes reference to the decision of the law of the Sea Tribunal, which heard the southern bluefin tuna case, Australia and New Zealand against Japan in 2000. And in that case, the tribunal prescribed certain measures outlawing experimental fishing programs for stocks of tuna, and that was based on the precautionary approach. Now, where there is harm caused to a sovereign entity, it is possible for the sovereign jurisdiction of the nation to be considered and to action taken. So what do we mean by this sovereignty concept and the sovereignty of nations? Sovereignty is important because it's a recognition by other nations that a state has certain rights to exclusive legal control over its land territory, or perhaps the airspace above the land territory, or the waters adjacent to a territory. So that's the concept of sovereignty. All right, I'll just talk briefly about the influence of international law in Australia. International law, of course, does exert, through policy and international treaties, a strong influence on the law as it applies domestically in Australia. But as we mentioned before, there is no automatic application of that law in Australia. To be effective, the international law must be translated into a domestic law and passed in the usual manner. I guess it's fair to say that from a federal environmental law perspective, there's very little environmental law, particularly that in the EPBCA, the Environment Protection and Biodiversity Conservation Act, which does not spring from international obligations. Now, there is a table in Bates which shows the way in which international treaties were eventually incorporated into the Commonwealth legislation, and that's worth having a look at. Conversely, however, not all international obligations or matters of concern do find their way into domestic law. Climate change and management of greenhouse gases are a good example in that instance. Now, that said, a court or a tribunal might be influenced by principles of international law or policy, even if there is no direct recognition in a particular case, but courts or tribunals are not bound by those situations if they're not made into domestic law. All right, so just in conclusion then, in relation to our discussions for environmental law, Bates refers to the decision of Leach against National Parks and Wildlife Service. It's a New South Wales decision from 1993, and in that case, the Environment Court of New South Wales accepted the legitimacy of the precautionary principle, even though the legislation had not yet been brought into practice at a domestic level. So I mention that because the precautionary principle is something that I want you to look out for when you're reading the rest of Bates' book. It's an important principle which is gaining more and more momentum and recognition. All right, thank you very much for your attendance today.